Frankly, who wants to revisit 2020? A year in which, if you were lucky, you got applications of alcohol both internally and externally. A year in which, if you were lucky, the world shrank to what you could see from your windows, and you became well acquainted with the decor of the walls of your colleagues' living rooms and bedrooms. So no, I won't be looking back at 2020. Instead, a few things to note for the start of 2021, in a view from my sofa. Much of life might have gone into stasis, but housing law never sleeps, particularly when regulations appear late on a Friday afternoon to take effect on a Saturday. The frankly chaotic handling of possession and eviction since March has been a feature of 2020, and there is every reason to suppose it will continue into 2021. The ban on evictions in England until 11th of January 2021, via belated regulations made after it was pointed out that stopping evictions by way of the Lord Chancellor writing to bailiffs was almost certainly unlawful, this will indeed run out on 11th of January. Now, as I record this, some 78% of England is under Tier 4 restrictions and likely to stay that way. Previous ban on evictions was for Tier 2 and Tier 3 areas. So, what is going to happen? Will there be further regulations? Will there be a further ban on evictions? And if so, when? Experience suggests they will appear late on Monday, 11th of January, and will just kick the can down the road again. Meanwhile, a case that appeared at the end of 2020, which we noted on the blog, the link is below, looks likely to cause something of a commotion at the start of 2021 once people notice it. Northwoods Solihull Limited and Fern and others was a High Court appeal on the issue of the signing of notices as a company. The High Court held that Section 8 notices didn't have to be signed in accordance with Section 44, Companies Act 2006, but the tenancy deposit certification did, as per the list of prescribed information in the Housing Tenancy Deposits Prescribed Information Order of 2007, which requires it to be signed specifically by the landlord. The certification in this particular case, in Northwood, took place before the Deregulation Act 2015 amendment, so the regs at that point only allowed the landlord to sign. But I think the implications are broader. Clearly, before 26th of March 2015, when the Deregulation Act amendment kicked in, any tenancy deposit prescribed information signed by anyone other than the landlord is in breach of Section 214, Housing Act 2004, and any such signed by a corporate landlord is in breach unless it's signed in compliance with Companies Act 2006, Section 44, which requires it to be signed by two directors, a director and a company secretary, or a sole director, but with their signature witnessed by another person. But what of the position after the Deregulation Act amendments? The amendment allowed the landlord, or the agent, to sign the prescribed information, but this depended specifically on who protected the deposit. The logic in Northwood was that statute prescribed signing by a specific person or corporate person. Arguably, I think very arguably, that remains the case, depending on who protected the deposit. It's either the landlord or the agent, not one or the other or both of them. What this would mean is that where either the landlord or the agent, depending on who was required to sign, is a corporate body, Section 44, Companies Act 2006 applies, and it has to be signed in accordance with that. Now, this is important both because it is a potential deposit rules breach and so attracting a penalty claim, but also because unless or until it is rectified, a breach means no Section 21 notice can be served. I very much suspect that a lot of corporate landlords will be caught by this, and in particular, a lot of corporate agents also, who, I think, are unlikely to have directors signing the deposit prescribed information. Now, we can't escape the pandemic, of course. While it continues to rage and the government backtracks from the message and funding of everyone in from April, the issue of how and under what power local authorities can assist homeless people not eligible for Part 7 obligations has become hugely important, particularly for those with no recourse to public funds. The government's position now is that councils have no powers to provide emergency accommodation to those not eligible for Part 7 assistance. Councils themselves are confused and contradictory on what their position is and what the law is. A judicial review on this issue, our N-Cube and Brighton and Hove Council, was heard on the 15th of December, and judgment is anticipated early in the new year. This could be a very important case for many street homeless, and is certainly one to watch out for. So, on we go into 2021, even if only visible from the chest up. Other things of importance likely to appear early in 2021 include the Building Safety Bill. Will this be changed in crucial respects from the draft bill, which frankly was a disaster for leaseholders? Will the Renters Reform Bill emerge? The signs seem to be that this will be delayed, although heaven knows why. And will the Charter for Social Housing Residents result in legislative proposals soon? Again, my sense is probably not. A happy new year? Well, we will have to see, but doubtless a busy one, and good luck to all.